The determination of the value of the property is obviously a key point in an eminent domain proceeding. The question is, who gets to testify about that value? We're going to start by going to a couple of locations in which a property owner was allowed to testify and a so-called expert was prohibited from testifying to help answer that question. We're at the Gerald Ford Presidential Museum. A case called Grand Rapids versus Terryberry related to the acquisition of a two-story building used for a jewelry business. The key issue was the extent to which the property owners were allowed to testify about the value of their own building. The Michigan Court of Appeals recognized that evidence is liberally admitted in condemnation cases. It then reviewed decisions that generally allowed lay people to testify about the value of property. The Court of Appeals affirmed the ability of property owners to testify about the value of their own property. It didn't allow it to be a universal rule because property owners needed to provide some general background establishing their knowledge about the attributes of the property itself and the real estate market that was being relied upon for their valuation. However, the Court of Appeals allowed property owners to testify even when the methodology that they employed was inconsistent with standard appraisal practices and where they didn't necessarily have firsthand knowledge about the market data that they were relying upon to formulate their values. Next, we'll go just south of here to Kentwood, where a supposed expert was prohibited from testifying. In a case called Jack Lokes versus Kentwood, the property owner brought a de facto taking claim against the city. When attempting to defend against the owner's valuation position, the city sought to introduce what it called an expert sensitivity analysis. It consisted of a so-called expert who had no experience in real estate and was not an appraiser, merely plugging random numbers into mathematical formulas as a means of trying to impeach the positions presented by the property owner. While the Court of Appeals once again acknowledged that evidence is liberally admitted in eminent domain cases, it held that this so-called expert did not offer anything beyond what a layperson could do. The jury itself was as easily capable of plugging numbers into a mathematical formula as this expert. As a result, that testimony was excluded. MCL 213.61, which is part of the Uniform Condemnation Procedures Act, has essentially adopted the holding of these two cases. Real estate appraising is now a regulated profession. Michigan has an occupational code which governs a wide variety of professions with a full chapter addressing real estate appraising. That statute includes a broad definition of what constitutes an appraisal. It establishes licensing standards to become an appraiser, and it establishes minimum thresholds for what a written appraisal must contain. It also requires appraisals to be of a specific date and be in writing. In MCL 213.61, these standards are adopted by reference. Essentially, anything that is governed by the occupational code governing real estate appraisers must be followed to be admissible in an eminent domain proceeding, with an exception. And that exception matches the Terryberry case. Property owners are not required to meet the licensing and regulatory standards of appraisers in order to be able to testify about valuation issues relating to their own property.